Hello and welcome back to another update in the Vallow Daybell case. Today we have a ton of filings to get through, so let's hop right into it. The first thing I want to go over is the judge's order denying the motion for reconsideration. If you remember, about 2 weeks ago, we watched the hearing on the motion to disqualify the special prosecutor Rob Wood, in which John Pryor and Mark Means brought forth their witnesses and tried to have Rob Wood removed as the prosecutor from the case for various reasons. That didn't end well. The judge ruled against them. And apparently, what you see on your screen is Mark Means on the 19th of January had filed for a motion for reconsideration. An odd tactic in a criminal case, but whatever. However, when we go to read that motion, it's not there. So I'm not sure if that's an error with the court or if they don't have it up for some particular reason, but we can't see the actual motion. However, we can see the judge's order denying the motion for reconsideration. Let's read through it. It's up on your screen. On January 19, 2021, defendant filed a motion for reconsideration requesting the court to reconsider and amend its order regarding the motion for disqualification of the prosecutor, Mr. Rob Wood. The motion cites the Idaho State Constitution, the United States Constitution, and any other applicable rule of law as the basis for the requested relief. While the Idaho Rules of Civil Procedure contain provisions for a motion to reconsider, there is no counterpart in the Idaho criminal rules. The Idaho Supreme Court has confirmed that there is no basis for such a motion. In fact, there is no criminal procedural rule that provides a basis to reconsider a decision of this kind. The Idaho Rules of Criminal Procedure have nothing similar to the Idaho Rules of Civil Procedure, so on and so forth. So that's the judge saying, number one, you can't just send me a motion that says any other applicable rule of law. That's not how this works. And number two, there's no basis for you to do this. This is not a civil case. This is a criminal case. It's time you got on board with that. So this was pretty cringeworthy to read. This is kind of the judge giving Mark Means a little smackdown and being like, hey, you need to learn how this works pretty quick because this stuff isn't going to fly with me. But regardless, his motion for reconsideration was denied. Is Mark Means going to try again? Probably. I hope not. I hope he's learned his lesson and moved on. So, that's all that happened with that. Alright, next up, there is a discovery battle going on between Mark Means and Rob Wood. So, there are a bunch of new filings from yesterday. We're going to fly through it kind of quick. If you're a law nerd like me and you want to read the entire documents, the PDF files are all uploaded into the Discord server, which you can access in the link in the description below. So, let's fly through it. On December 17th, 2020, Mark Means filed a specific request of discovery, asking for all kinds of stuff. On January 8th, 2021, Mark Means filed a motion to compel with the court, saying, hey, judge, he's not giving me my stuff. Make him give me my stuff. On January 14th, 2021, Rob Wood filed a discovery disclosure saying, judge, here's all the stuff. On January 25th, Mark Means filed a supplemental declaration saying, judge, he still hasn't given me all my stuff. On February 9th, 2021, Rob Wood filed a supplemental disclosure being like, dude, here's all the stuff. I told you where it was. And that brings us to February 11th, where Rob Wood has filed this disclosure, which is kind of a big deal. We're going to read through this a little more slowly. I'm going to put some highlights up on the screen. So here we go. Page 1. The introduction. On or about December 17, 2020, the defendant Lori Vallow Daybell filed a specific request of discovery pursuant to Idaho Criminal 16 and served it upon the state. But what he says is the defendant's request falls outside the scope of Idaho Criminal Rule 16 and is unreasonable and oppressive in its expansiveness. Despite already receiving over 38,000 pages and 700 gigabytes of written and digital discovery, the defendant now requests work product materials that are explicitly non-discoverable. Further, the defendant failed to follow the brief required procedure prescribed by Rule 16b for information not otherwise covered by Rule 16. For these reasons, and as further explained in the brief, the court should deny the defendant's motion to compel. Right, he goes on to state applicable law, the standard of review, prosecutorial responsibilities, but here's an interesting highlight for those of us interested in how all this works. The prosecutor is not required to deliver his entire file to defense counsel. Due process, though, requires that the prosecutor disclose to the defendant all material exculpatory evidence known to the prosecutor in his possession. Okay, he also cites that work product is non-discoverable. In page 3, Rob Wood goes on to describe what information held by the prosecution is not subject to disclosure, and he has case citations and lots of good information there. On page 4, we continue on with this. And this highlight from page 4 I found interesting. The defendant's request is illegal and defective on its face. The court should deny the defendant's motion to compel on the following grounds. A. The defendant's request is outside the scope of Rule 16 and is unreasonable and oppressive. The defendant's specific request for discovery is far beyond the scope of Idaho Criminal Rule 16, and there is nothing in Rule 16 that requires a prosecutor to disclose to the defendant every person, witness, potential witness, or person of knowledge that they have conversed with about a case. That makes a lot of sense. He says that the defendant's request of conversations with all persons is so vague and overbroad as to make such a request impossible to comply with. I agree. Moving on, page 5 is more arguments put forth. If you want to read it, it is interesting. Lots of case citations and historical precedents. Page 6, more of the same. The defendant has failed to follow the procedures required. Again, he's calling Mark Means out for not doing it right. It's like he doesn't understand what he's doing. He's not doing it right. Judge, make it stop. He closes by saying the state acknowledges that it filed its response objection to the defendant's specific request for discovery 8 days after the 14-day deadline, so he's asking the court to basically find good cause the state has not waived its right to object the defendant's specific request for discovery, yada yada yada. Just basically saying, yeah, I know it's late, but here's why it's late, because all this stuff is crazy. And he's asking the court, he said the defendant's specific request of discovery pursuant to Idaho Rule Criminal 16 is illegal and defective. So, because of that, please tell him to stop. Please deny his motion to compel. So, that's the first filing. All right, the next filing, this is Rob Wood's response to supplemental declaration of counsel Mark L. Means in support of the motion to compel. Right? Basically, he's saying that the state couldn't verify whether Mr. Pryor had yet received the following phone device and forensic reports, listed as Alex Cox, Sidney Woodbury, Chad Daybell, Charles Vallow, HSI Filter Review, Melanie Boudreau, Tylee Ryan, her iPad, and Zulema Pestenes. On January 19th, 2021, the state emailed John Pryor saying, we are sending you a hard drive with all of that information later that day. He also goes on to say that the same phone device forensic reports listed above were already provided to Mark Means in May of 2020 as part of the Madison County case. So, he said, as of this date, both Mr. Pryor and Mr. Means have each received the same discovery materials. So it seems like the hard drive that Mark Means is yelling about that was sent to John Pryor on the 19th was actually sent to Mark Means on May 18th of 2020, and he forgot or lost it or something. So that's what that's about. But hang on, there's more. All right, and last up for today. If you all remember, a couple of weeks ago, Mark Means filed a motion with the court asking for Lori to be given a cell phone because he believes that her right to have privileged conversations with her attorney has been compromised by the COVID restrictions in place at the Madison County Jail. Now, I did a live stream. I talked a lot about it. I have kind of a controversial view. I believe that her right to privileged communications is essential and needs to be preserved, and something has to be done. Should it be a cell phone? I don't know about that, but something needed to be done. All right, here's Rob Wood's response to this, and it's pretty brilliant. So let's go through it. I'll put some highlights on the screen. You can read the full document later on in Discord if you want. Now, page 1 is missing. I don't know why. It's not there in the filing. The PDF page 1 is just blank. So we're going to jump in with page 2. The first highlight for you. He starts off with, the state objects to the defendant's request for a cell phone for the defendant. Idaho Code, yada yada, lists cell phones as a contraband item for individuals detained in a detention facility. Okay, so he's got a point there. She's not supposed to have a cell phone. No one is. He goes on to explain the Idaho Code that prohibits cell phones and all of this stuff, and he makes a very reasoned argument. Also, further down the page, in the second highlight here, he says, the defendant already litigated these same facts at a bail reduction hearing on the defendant's amended motion for bond reduction on or about May 1st, 2020 in Madison County, and cites the case number. Now, I've referred to this hearing several times. This was a 3.5-hour hearing where the entire hearing was about this exact point by Mark Means. And we've already litigated it. The judge already ruled on it, and here we are doing it again. You seeing a pattern here? I am. All right, moving on to the next page. Rob Wood talks a lot about not only is Mark Means relitigating something that we've already been through, but he's asking for special privileges because every other inmate in the Madison County Jail is required to use the Telmate system for telephonic communication with their legal counsel. He points out something interesting. What's supposed to happen is the legal counsel is supposed to contact the jail, give them their number, and that number is supposed to be blocked so it won't be recorded. Mark Means didn't do that, which is why one of their calls was accidentally recorded. So the state was the one who contacted the jail and said, this is the number, this number needs to be blocked. So this is Rob Wood taking an action to protect Lori's rights to privileged communication that Mark Amin should have taken but didn't. So I don't think the state is in the wrong here. Okay? I mean, my goodness. But the most interesting part comes up where at the top of this page, where it says, not only is the defendant attempting to relitigate facts previously decided by the court, she's also litigating those same facts through social media. On or about February 5th, 2020, Mark Amin's counsel for Lori Daybell published a series of tweets on the social media app Twitter, in which he reasserts the false claim that the state is or has wrongfully recorded attorney-client conversations. Oh, goodness gracious. So he enters those tweets, some of the tweets, as State's Exhibit 5. Now, how many times have we all sat here and said, Mark Means, you gotta stop tweeting. Quit it, dude. Just quit it. Because as Rob Wood says, doubling down on claims already denied by the court on social media serves to create more pre-trial publicity. Period. Now this is going to come up in the change of venue. Rob Wood is going to bring up all of Mark Means' tweets in the change of venue hearing. And it's too late. The tweets are out there. Everyone has screen captures. He can't delete them. Maybe he'll stop tweeting going forward because he's certainly not going to help his case. But geez Louise, this is getting a bit silly now. So that's what all these filings are. If you want to read them in their entirety, come over to Discord, grab the PDFs. They're all there. You can slow down the video and watch them that way if you want. But now you're up to date. You know everything that's happening. The next thing we expect to see is the hearing on the 17th. And if that happens, great. If not, well, who knows. But there could be other things coming up in the meantime, so please stay tuned. Also, have a wonderful Valentine's Day. Whether you celebrate it or not, I still hope it's a beautiful day. And stay safe out there. We're having our winter blizzard, and I'm about to get snowed in, and I'm really looking forward to it. I think it'll be fun. So I'll talk to you as soon as there's any more news in the case, and have a wonderful weekend.